Can you hear me now? Yay. But I don't know if I'm recording this. Oh, okay. I'm concerned. I'm concerned that I see a recording alert. Can you hear me now? I'm just going to leave well enough alone and not say anything. Hi, everyone. I want to welcome you to our webinar. We will be starting it in a couple of minutes. I see that a few people are joining us. I just wanted you all to know that I'm here and we will start our webinar shortly. Thanks. Hello, everyone. Thank you for joining me today on my probate webinar, where we'll talk to you about what is probate, what does it cost, what does it entail, and how you avoid it. My name is Christine Brown. I am an elder law attorney in Torrance, California, and my practice consists solely of elder law, which is estate planning, conservatorships, limited conservatorships, special needs planning, probate, trust administration, and Medi-Cal planning. My webinar is going to be solely based on California law. Every state has a different way of handling their probates, and this one is just specifically for California. I get a lot of questions about probate, and that was the reason why I wanted to do this webinar. So most people who say that they have to handle someone's probate usually gets a response from other people like, oh my gosh, that's terrible, don't do it, it's horrible, it takes forever, and it's so expensive. And the person who made the initial comment is kind of taken aback by those statements, because most people that have to go through the probate process don't really know what it is or what it entails. So, and that's okay, because most people don't deal with probate. It's not like divorce law where you hear about it on TV, you see it in movies, and things like that. So let's talk about when and why does probate happen. So here in California, if you pass away and your assets have a gross value of $166,250, and those assets are in your name alone, you will be having an estate that is subject to probate. So when we talk about assets in your name alone, we're talking about assets that do not have a beneficiary designation. They are not designated as payable on death, transfer on death, because those types of assets, because they have beneficiaries, regardless of the value, they bypass probate. They immediately or shortly after your death go to your named beneficiaries. The same holds true for assets that you co-own with another individual. So if you own a bank account with your brother Bob and you pass away, that bank account belongs to your brother. If you own a piece of property in joint tenancy with rights of survivorship, or as community property with rights of survivorship, your asset will pass to the joint tenant or to your spouse. If you own property as tenancy in common, then unfortunately that's not considered a beneficiary designation, so to speak, and that asset will have to go through probate. So what is probate? Well, probate is a court process that's initiated in your local superior court. It's the county in which the decedent died and was a resident of at the time of their death. So for example, if you're traveling and you are a resident of LA County, but at the time of your death, you were traveling to Hartford, Connecticut, your probate is not in Connecticut, your probate is here in LA County. So when a probate is necessary, what happens is that the court will give your personal representative the authority to transfer title of your assets to your heirs or your beneficiaries. Because at this point, because you've passed away, you're not around anymore to sign a deed over to your beneficiaries or to sign a pink slip to your grandson, as you would have been were you alive. So in order for the title to transfer from your assets to your beneficiaries, there has to be a person put in place and given legal authority by a court order. And what a lot of people don't realize is a will has no legal effect until it's admitted by the court into probate. And I only bring this up because numerous times a year, I get a phone call from somebody who's named as the executor under a will, and they want to start taking action. Well, we have to break it to them that the will is a legal binding document. However, it must be admitted to probate to give the executor authority to manage the deceased person's estate. Some of you have perhaps heard, the phrase, he died intestate, or maybe you even heard she died testate. So what do these terms mean? So dying intestate means that a person died without a will in place. When you die intestate, the state law determines who inherits your estate. And your heirs under California law, for example, if you are a married person and you have children, your next of kin would be your spouse and your children. If you're a single person who is not married, then your estate, if your next of kin could be your parents, if they're still alive. If not, it could be your brothers and sisters. So for example, let's say you pass away and you have one brother, your brother Bob, and you have not spoken to him in 20 years. You had a horrible falling out. You don't want to see him. You don't want anything to do with him or his family. If you die without a will, it goes to your brother. It's just the way the probate code is set up. Or let's say you're in a long-term relationship with an individual. It can be an opposite sex individual or a same-sex individual. If you are not married, they are not your next of kin. California does not have common law marriage. So just because you're with your partner for 10 years and you've been living together and holding yourself out as husband and husband or husband and wife, they are not your spouse under the California probate code. So for example, let's say you are in a long-term relationship and you want that person to inherit your home and you die without a will, your loved one does not get the house. The house will go to whoever your next of kin is. And sometimes I hear people say, well, I don't want to die without a will because I don't want the state to get everything. Well, the state rarely, if ever, gets everything if you die without a will. What happens is probate will be opened either by a family member of yours, a friend, maybe even the public administrator's office, which is a county entity. They would open up the probate, and there are heir search firms out there that will find your next of kin. So at some point in time, you will have a beneficiary of your estate. I currently have a probate, just to give you a brief example, where a woman passed away. She'd never been married. She never had children. She didn't have a will. And what ended up happening, her estate went to 27 different family members. Some of them were cousins, but most of them were first cousins once removed. And the majority of these people did not even know her. They never met her. Some of them didn't even know they existed. So it's really important to have a will in place so that you can dictate how your estate is distributed. So that's when we come to dying testate, which is dying with a will. In that document, you can name your personal representative. And when you have a will, your personal representative is called an executor. If you die without a will, your personal representative is called an administrator. I just wanted to point that out because sometimes people use those terms and you may not know exactly under what circumstances those people are acting under that title. You can name your beneficiaries. So like in my example before, you don't like your brother Bob, you can specifically disinherit him and leave everything to your favorite charity, or you can leave it to your friends and your favorite charity, or however you want to distribute your estate, you can name beneficiaries. Also, in the example where you have a long-term partner, you can name him or her as the beneficiary of your estate. Even if your family is up in arms and they're angry that you left everything to your long-term partner, that's too bad. You're allowed to give your estate to whoever you want to give it to. And again, you also control the conditions under which your beneficiaries inherit your estate. So you could say, for example, you wanted to leave an inheritance to your favorite nephew, but you wanted him to get the asset or the share of your estate at a particular age. You could do something like that in the probate. So why do people hate probate? Well, there's a couple of reasons. Number one is the time involved in a probate. So here in Los Angeles County, as well as in Orange County, prior to COVID, which kind of threw everybody for a loop, on average, your probate from the moment you filed it through the whole process until you got the final court order from the judge closing your probate was on average 12 to 18 months, which is a long period of time where the assets of the estate are in limbo. They're being watched over by the executor, and bills are being paid, assets are being liquidated, but it takes anywhere from 12 to 18 months before the beneficiaries actually receive their inheritance. It's a public procedure. Anyone, your next door neighbor, your best friend, your worst enemy, could go down to the courthouse and look at the file and see what's going on. People can go to the hearings on your probate matter and hear what's going on. When you file documents with the court in a probate, you have to set out all of the deceased person's assets. You have to list all of the decedent's bills, their creditors. It's all part of the public record. And some people are very private and they don't want everybody to know what's going on with their probate. Probates are under the court supervision, which is not necessarily a bad thing because it's nice to have little checks and balances with the executor. But when you ask for court supervision, or when you have court supervision, I should say, every time you appear before the court, you have a filing fee. And here in LA County, it's slightly more than $494, which means every time you have to appear before the judge, when you file a petition, it's $494. There are other entities involved with the court. The probate referee also gets a small percentage of the value of your estate. It's 0.1%. And they will value the assets in the estate for the court. If you have a probate, you might need court approval to sell real property, which is also an expensive proposition. It's another petition that you have to file, and also takes time to obviously work its way through the court to have your hearing, to get your order approved and all that kind of stuff. Let's say you have a beneficiary of your estate who has Down syndrome. And when you have a will, or if you have a probate even without a will, if you have an incompetent beneficiary, what ends up happening is the court will require that the incompetent beneficiary have a probate conservatorship established for them. And what that does is yet another expense. And the court is then even further involved, because when your Down syndrome beneficiary receives their inheritance, it's put into their conservatorship, and the probate court supervises that conservatorship until the money runs out or the conservatee passes away. It's just another level of fees. Same thing if you have a minor beneficiary and they're inheriting under your probate estate, the court will require that someone establish a guardianship of the estate for the minor. So when the probate is getting ready to close and you're about to distribute the money to the minor, you distribute it to his or her guardian. The court is now involved in the supervision of that guardianship, which has its own level of filing fees and expenses and accountings that need to be done on a regular basis. And a guardianship here in California ends at the age of 18. So you may have an 18-year-old who will end up with hundreds of thousands of dollars on their 18th birthday or shortly thereafter. And a lot of people that I do estate planning with don't want an 18-year-old running around with hundreds of thousands of dollars, because they just don't have the maturity to understand the value of money and how to invest it properly and to save it and to be very conscientious with what you do with it. I talked a little bit about the filing fees. The probate referee, as I mentioned, gets 0.1% of the gross value of the assets he or she has to inventory and appraise. You have to publish when you file a petition for probate. You have to publish in a local newspaper. I've seen it ranged anywhere between $300 and $600. It depends on where you live, what local newspapers are in your area. But probably the most, or the largest cost, and probably the most shocking aspect of probate is the statutory fees and commissions that the executor and his or her attorney receives. That's when people, like the picture shows, hold up their hands and just in horror can't believe what the statutory fees are. The statutory fees and commissions are based on the gross value of the probate estate. So let's say you have a $1.2 million home and a $1 million mortgage on it. So the equity in my example is $200,000. It really doesn't matter about the equity. It matters about the value of the house. So if the house is 1.2 million, that is the value that's used to calculate the statutory fee. And also, it's not only the date of death value of the assets, you also add in all of the receipts of income that you receive during the course of the probate. So it could be dividends, interest. Let's say you actually ended up selling the house and there was a gain on the sale, that becomes part of the statutory fee and commissions. Also, if you sell the real property and there's a loss, the loss will then reduce the value of the estate upon which the statutory fees and commissions are calculated. So let's do an example of $1 million probate. Your statutory fee is 4% of the first 100,000, 3% of the next 100,000, and 2% of the next $800,000, which is $23,000. And that statutory fee is not shared between the attorney and the executor or administrator. Each party gets $23,000 as their statutory fee or their statutory commission. Now, on top of that, there might be extraordinary fees. Let's say you had to sell 3 pieces of real property during the probate. You could ask for extraordinary fees. If there is a business in the probate that needed to be sold, that's an extraordinary fee. We probated a probate last year where the decedent was an attorney. So we had to go in and get a law practice administrator appointed. And that was another extraordinary fee. And those fees are for both the attorney at his or her hourly rate and also for the executor and administrator at their hourly rate. Here in LA County, it's usually around $50 to $60 an hour, unless your executor administrator is a professional, such as a lawyer or a doctor. For some reason, the courts allow them to get a higher rate. I think the theory being that they're away from their practice, they're not earning money, so therefore they should get a higher rate than perhaps an average person. So I get this question from people that say, can I do my do-it-yourself estate plan to avoid probate? And yes, you can. I'm not going to talk about LegalZoom or any other online entities, in part because I don't know whether they're good or not. I assume that they're legally sound. And usually the quality of the documents is not the issue. What I find with a lot of do-it-yourself estate plans, because I end up having to fix them either before the person passes away or after they've died, which is worse, and it's far more expensive to fix it. But I find that people, for the most part, if you have a really simple estate, you say you have one child and you want to leave everything to them and you want them to be your executor, it's pretty hard to mess up your do-it-yourself plan. But what I find is people just don't understand what they're signing, what box they're checking. And that's where you run into problems, is if you don't understand what you're writing or what you're agreeing to, the people that are left behind, so to speak, they may not understand it either. And if there's inconsistencies, that's where the problems arise. I had one example where I was reviewing a will, and in the will, there was a specific bequest that said, I give my house to my brother, John. And then another portion of the will, it said, I give everything that I own, my home, my car, my bank account at B of A, my bank account at Chase Bank, my Charles Schwab brokerage account, to my favorite sister, Sally. Well, there's an inconsistency here. You wanted the house to go to your brother Bob in one part of your will, and you have another bequest to, or a similar bequest to another person. So who's supposed to get it? If the beneficiaries get along, hopefully they can come to some resolution, but sometimes beneficiaries don't get along, and these inconsistencies end up in probate court, where we have to file a petition for instructions with the judge, explain the circumstances, and let the judge make a decision if we're not able to come to an agreement beforehand. And that's just expensive. And that's why a lot of litigators love do-it-yourself estate plan. They love when you do this because they end up making a lot of money off of a probate estate that they wouldn't otherwise make. So it's always good, if you do your do-it-yourself estate plan, make sure you understand what you're doing. So what exactly is the probate process? Well, what we do first of all is, when somebody comes to us, our first question is, what is the value of the total assets? You may remember early on I mentioned that here in California, a probate estate is at a minimum $166,250. So if your assets are less than that, then no probate is required. If you have real property that's less than $166,250, there's a summary probate that can be done in the probate court. It can either be done by a petition that has, it's like a one-time petition. It's easy, it's simple, takes relatively little time to do it. If you have cash, a brokerage account, an IRA account, for example, that is less than $166,250 and has no beneficiary designation, what happens is you must wait 40 days after the person's passed away, and then you can go to the bank or the brokerage house along with a death certificate, and they will ask you to sign an affidavit attesting to the fact that you are the decedent's next of kin. And if you are the decedent's next of kin, you can collect it. If there's more than one beneficiary, so for example, if you're a single person, you died and you have 4 siblings, all of your 4 siblings will inherit if you have no will, and they must sign the affidavit and they will collect their share from the bank or the financial institution. Then we ask, is there a will? And then I look at the will and I need to make sure that it's a valid will. So if it's typewritten, are there 2 witnesses? Did the decedent sign it? Does it say it's a will? Or is there language in the document that leads me to believe that it is a will? And is it dated? A mistake that I see with some typewritten wills are they're notarized. Here in California, we do not notarize our wills. The notarization does not make the will valid. There are also holographic wills, which are written entirely in the decedent's handwriting. So we look at that and say, okay, is it all in the decedent's handwriting? Is it dated? Is it signed? Is it clearly identified as a will? And then we can go forward. Either a valid typewritten will or a valid holographic will can be admitted to probate. So we file the petition for probate. And as I mentioned a little bit earlier, after the petition for probate is filed, we publish in a local newspaper, and then we have a hearing. Here in LA County, as well as Orange County, you don't, if you're the named executor administrator, you don't have to appear in court. And I like to joke with my clients that if they do their job correctly, they will never have to set foot in a courtroom during the probate process, because I can make appearances for them and it's much easier. So after the petition for probate is filed and it's approved by the court, the executor is put into place, or the administrator. At that point, you have to give notice to the creditors. The executor administrator will go through the decedent's bills and determine who is a creditor. It could be the mortgage, it could be a landlord, it could be a medical bill, it could be a phone bill. Credit card bills are usually the biggest or the most common debt. And once you're appointed, you send out a written notice to all of the creditors that you found. They have 4 months in which to file a creditor's claim in the estate. If they don't file a creditor's claim in that 4-month period, they waive their right to collect on the debt. And while it doesn't always happen, we have had creditors who just forgot to file a creditor's claim and their debt was not paid by the estate. During the process of probate, the executor will inventory the assets. That doesn't mean you have to list 5 tumblers, 7 plates, 12 forks, 3 wine glasses. No, none of that. We're talking about cash. So the executor will get the date of death balances on all bank accounts. The probate referee comes in to appraise the assets that fluctuate in value. So for example, real property, stocks, bonds, mutual funds. as well as personal property. Again, with the personal property, most people have furniture, knickknacks, that type of thing that have relatively no value, not to offend anyone, but you usually can't sell it for much at an estate sale. So what we do with that personal property, we just attribute a value to it that we find to be reasonable. And then during the probate, the executor or the administrator will also have to liquidate the assets. So if you have a probate where you have, let's say, 3 or 4 beneficiaries and there's a house involved, most of those beneficiaries don't want to own real property with other people that they may not know, or maybe they do know them. So the executor administrator will have to liquidate the real property and sell it. And as I mentioned before, you might need court approval to do that. And then once all the assets have been liquidated, all the bills have been paid, tax returns have been filed, then the executor administrator will file a final accounting to close the estate. There's a hearing on that. The court will issue an order directing the executor or the administrator how to distribute the estate. And if you're the executor, you must distribute the estate exactly as it's written in the will. And if you are the administrator, you must distribute the assets exactly via the laws of intestacy under the probate code. And if you don't propose that distribution, the court will correct you and they will issue an order stating the way the estate needs to be distributed. Sometimes my clients ask when they're starting a probate, on what grounds can people contest a will? They're always worried that somebody's going to come in very dramatically in the courtroom and, say, oh, I'm going to, contest this will. Well, usually that doesn't happen. At least I haven't seen it. So the most common grounds that I see for a will contest are lack of capacity, undue influence, and the testator did not sign the will. So lack of capacity is usually brought up when somebody is suffering from Alzheimer's, dementia, or some other cognitive decline shortly before their death, and a will was executed after the diagnosis was made. So let's say you have been diagnosed with Alzheimer's, your will was created a year or 2 before the diagnosis. Chances are there's not going to be a lack of capacity issue. It's more so someone lacks capacity, a family member or friend takes the individual to an estate planning attorney, or they have them sign a will after the diagnosis, obviously, and shortly before they die. That's usually where it comes up. Undue influence, that means somebody signed a will and they were done. The will was signed because somebody was encouraging them to do so and making them feel guilty about it, maybe even saying, look, if you don't sign this, I'm going to leave you behind. There's not going to be anybody to take care of you. You're going to be at home all by yourself. Nobody cares about you. I'm going to be gone. There's going to be nobody to take care of you. And the other common ground is the testator did not sign the will. And that's literally what it sounds like. People will look at the will and say, that doesn't look like my Aunt Barbara's signature. Or maybe if it's a holographic will, they might look at the will and say, that's not my Aunt Barbara's writing. She didn't write like this. She didn't sign this will. She didn't write this will. We're going to contest the terms of the will. And the other ones are fraud, duress, mistake, and revocation. But the most common ones are the first 3 that I spoke about. So duress is when somebody is unlawfully confined or detained by another party, and that party forces them to sign a will. Mistake is another grounds to contest the will. It's not really so much the validity, but if there's a mistake in the will. So for example, let's say you were promised the decedent's bank account, and when the decedent wrote his or her will, the bank account went to another party, you can contest the will on that ground of mistake. Revocation, that basically says, hey, this will was revoked by a will that was done later, and I have the new will, and this is the will that can be admitted to probate. So when you're in the middle of the probate process, clients always ask me, what information are the beneficiaries entitled to? Because as an executor administrator, you may be getting phone calls on a regular basis from the beneficiaries who are just very curious as to what is going on. So the number one thing that they're entitled to is a timely administration. In LA County, your probate must be opened and closed, or correction, you must open and file your final accounting within 12 months after you've been appointed. So it has to be timed. You cannot take your sweet time to administer probates. The reason we now have the court coming down on executors is because people in the past have taken their sweet time in probating estates. And it wasn't uncommon to have probate estates open for 5 years, 10 years. This is a crazy amount of time. So now the courts keep a close tab on the executor administrators. There's dates by which you have to close the probate. And if you don't close it by that time, you need to explain to the court why and get a court order authorizing you to keep the probate open for a longer period. So for example, I mentioned a probate earlier where the woman passed away and had 27 beneficiaries. Well, we weren't able to close that probate in 12 months, in part because we couldn't locate all of her heirs. The heir search firm was having a heck of a time trying to find all of them. So we had to ask the court for permission, which they granted because they understood it was a very unusual circumstance. It wasn't like my client was not doing his job. He was, but there were certain extenuating circumstances that arose that we had to ask for time. Give them notice of major events. So if you're a court supervised probate and you're selling real property and you need court approval to sell it, you're going to give notice to the beneficiaries. They're going to know the date and the time of the hearing. They're also going to know how much you're selling the house for, to whom, on what terms, who the realtors are, what their commission is. So they know what's going on, and they have the opportunity to object to the sale. There are probates where we don't need court supervision to sell real property. And those instances I recommend, and it's also required, that my clients send out notices of proposed action. So they would explain to the beneficiaries, the house is being sold for $650,000. The buyer is John Smith and his wife, Mary. They put a down payment of $50,000. Their realtors are going to get a 5% commission. These are the conditions. These are the terms of the sale. They, the beneficiaries, then have 15 days to object to the notice of proposed action. If they don't object, it's deemed to be a consent. And if they do object, then you just go to court and get court permission to sell the house on the terms that you have designated. And that's really important because I find that there's a lot of Monday morning quarterbacking with beneficiaries sometimes, like with regards to the sale of the house. If you give them a notice of proposed action, they can't come to you 3 or 4 months later and say, hey, you should have held on to that house because we didn't know at the time, but 2 months later, Google announced that they were moving their headquarters to Santa Monica, and that's where the house is, and we could have gotten another $200,000 on the house. Well, you're only responsible for the facts you know, and you don't know those facts at the time. But at least you can say in this example, look, I gave you notice. I told you I was going to sell it for $650,000, and that's what I sold it for. You have no right to object, and you can't contest the sale because it's happened and it's over. So also I find that the more you give the beneficiaries information, the better, because secrecy breeds paranoia. If you're not disclosing things to the beneficiaries. And I don't mean you have to disclose every single little thing that you do, but if you don't keep them apprised of what's going on, they think something wrong is going on, or that you're going to run off with the money, or you're doing something improper. I mean, their ideas go all crazy. So it's better just to keep them advised of what's going on. And they're allowed to know what the assets are, what their values are, what their values are. And all that information, as I mentioned earlier, is part of the court file. So if you don't have that information available at your fingertips because you don't have your file in front of you when you talk to them on the phone, they can always go to the courthouse and look up this information. It is there. So what about if you have a person that passed away and owned property in other states? Let's say they have a vacation home in Florida, or maybe they have a cabin in Montana. What happens to those assets? Well, those assets, because they're real property, will not be subject to probate here in California. You would have to open an ancillary probate in the state in which the property is located. So in my example here, I have 4 pieces of property. So let's say there's a house in Florida, a cabin in Montana, a house in Oregon, and a condo in Hawaii. In this scenario, which is a nightmare, I'm gonna admit that right here, you have to open 4 separate ancillary probates, 1 in each of those states. And I can't really speak to what an ancillary probate is like in Florida, Montana, Oregon, or Hawaii, but it may be that it's a very simple, short, one-time hearing process, or you can be like California, where if you have, let's say, an Oregon resident who has property in California that's worth more than $166,250, you have to do a regular California probate, the same time period, it is the same statutory fees. But I think from my experience with other states, it's usually a lot simpler, less expensive, and fairly quick. So how do we avoid going through probate when we pass away? Well, the easiest way, maybe the least possible, I think, would be to die with less than $166,250 worth of assets, or no assets. Because if you have little or no money, there's no probate that's involved. Name beneficiaries on your assets. It's easy to do with life insurance, IRAs, bank accounts, brokerage accounts. All those financial entities are very well versed with adding beneficiaries on those accounts or assets, as well as contingent beneficiaries. If this is the route you want to go, just make sure that you update your beneficiaries along the way. Because if you name your friend Frank and your other friend Susan, and they die before you, well, then you have no beneficiaries on those assets. And if those assets are a probatable amount, they will end up in probate. I don't recommend adding people as co-owners on real estate. There's some other legal reasons why I don't like that. I'm not going to go into that here. That's a whole different conversation. But here in California, we do have transfer on death deeds. However, those are expiring on January 1st, 2021. The transfer on death deed is what it sounds like. You have a deed. On it, you say, upon my death, I want my property to go to my friend Charlie. So after you pass away, there's a little bit of administration that needs to go on with that, and then the property transfers to your friend Charlie. I'm not really sure why the transfer on death deeds are now expiring on January 1st of next year, but I suspect that it has to do with either one of 2 things. One is there may have been a lot of fraud, or 2, people didn't really understand what they were signing. And I know A lot of title companies were very hesitant to deal with properties that were transferred to someone via a transfer on death deed. They usually required kind of like a holding period where the property couldn't be sold for a certain period of time, and then the beneficiary could sell it. Again, they did that because they wanted to make sure that the transfer was legitimate. So if you do have a transfer on death deed, if it was executed before January 1st, 2021, they're still valid. They can still be used as a probate avoidance tool. It's just that those that are going to be executed after January 1st will have no legal effect, so don't do it. The most popular way here in California to avoid probate is to do a revocable trust. So what is a trust? Well, a revocable trust is also known as a living trust, a family trust. It really depends on the attorney that's drafting it. I tend to use revocable trust, and sometimes I use family trust as well. It just depends kind of, I think, on my mood or my client's mood on what we do. So when you have a trust, it allows you to transfer your assets upon your death to your beneficiaries without going through the probate process. When you create a trust, it's you entering into a contract with yourself. If you create the trust, you're called the settlor. You can also be called the trustor or the grantor. Again, it depends on the attorney that drafted it. I like the term settlor because it's different enough from the word trustee so people don't confuse the two terms. So if you create the trust and put your assets into the trust, you're called the settlor. You will always be the settlor of your trust because you put your assets into the name of your trust. You have control over it. The person that's managing the assets in the trust is called the trustee. You may start off as the trustee of your trust, or you can name another person if you want, but that's a little bit uncommon. You will not always be the trustee of your trust. If you pass away, if you resign, or if you become incapacitated, you can no longer be the trustee of your trust. And then your trust will dictate who will be the next named trustee. Your trust is similar to a will because it directs who will inherit your estate and who will be in charge of your trust upon your death. But the trust also has instructions on how your trust will be managed for your benefit if you became incapacitated. You may remember that I mentioned that a will has no legal effect until it's admitted into probate. That is not the case with the trust. A trust is effective the moment you sign it. So you're probably wondering, why is there a picture of a red wagon on my screen? Well, I'd like you to think of your trust as a little red wagon. As a kid, you may have had a little red wagon. I did. And we put our favorite possessions in that wagon. I think mine had probably my cat, a few Barbies, and probably a can of Cactus Cooler or something. But you take your wagon wherever you go, right? So as a kid, you took it to the park, you took it to your friend's house, you took it, to the ballpark. A trust is similar to a red wagon because it holds all of your possessions, your assets. You will put your house into your trust, you will put your investments into your trust, and you'll put your bank accounts into the name of your trust so that wherever you go, your trust will go with you. And if you think of your trust as a wagon, everything in your wagon, everything in your trust goes along with you. And as the trustee, you hold on to that handle, right? And you go through life with your little red wagon. So, and you, if you're in control of the wagon, you control what assets go into your trust. You also control what assets come out of your trust. However, if as trustee you drop that handle because you've died or become incapacitated, your trust's named an alternate trustee. That person picks up the handle to your little red wagon, also known as your trust, and keeps going through life managing the assets for you while you're alive, and then they manage the assets and distribute them after you've passed away. See, while you and I can die or become incapacitated, your trust cannot. It will continue being in existence until all assets have been distributed to your beneficiaries. So again, this is done without probate. There is administration. A lot of people think that if they have a trust, once they sign it, they put it in their desk drawer, they're done, everything's fine, nothing else has to be done when they die. Well, unfortunately not. As in everything in life, there's always a little bit of administration and a little bit of paperwork. It is nothing like a probate estate. Trust administrations take place in the privacy of your attorney's office, your CPA's office, and your financial planner's office. None of this is subject to public scrutiny. And there is things that happen. The time limit for a trust administration really depends on how fast you can handle the issues, selling real property, liquidating assets, that kind of thing. The cost is nowhere near the statutory fee. If it is near the statutory fee, it's because there's something going on with regards to a trust contest, or maybe you have a difficult beneficiary or difficult beneficiaries who, let's say, one of them's living in the house, you have to evict them, and they're just causing trouble. That will obviously drive up the cost of a trust administration. There's also benefits of having a trust that you don't otherwise have with a will. You can include special needs trust provisions. So let's say you have a disabled beneficiary that you want to leave money to, but they're on public benefits like SSI or Medi-Cal, and you don't want those public benefits to be affected by an inheritance. Well, you can put a special needs trust provision in your trust, which will allow your disabled beneficiary to receive an inheritance and not have it affect their public benefits. You can dictate how your children will inherit your estate. So you may say, I want my daughter to receive her inheritance at the age of 35, which is not the case if it's a normal probate. Or you can say, I want my son to inherit half when he's 25, half when he's 35. And you can put whatever ages and percentages you want. Let's say you have a child that spends money the moment it hits his bank account, and you're concerned that if they come into several hundreds of thousands of dollars, that they're going to be destitute within 12 months. Well, you can allocate that the money be distributed out. For example, let's say they get an annual distribution equal to their annual salary. Or maybe you just want the interest income to be distributed out for the first 10 years, and then you parcel out the remainder over time. Let's say you don't care for your daughter-in-law and you're fearful that if your son inherits your estate, that she's going to divorce him and take half of it. You can hold your son's inheritance in trust for him for the remainder of his life. He'll still get the benefit of using the assets, they just remain in the name of his trust and not in his name alone, whereby eliminating the possibility of him adding his wife as a co-owner to those assets. If you have a beneficiary, a loved one that has substance abuse problems, you can also put conditions upon them receiving their inheritance, be it going to AA meetings, NA meetings. Maybe they only get a distribution to pay for their rent to make sure that they don't become homeless. And obviously you can name contingent beneficiaries. You're not just limited to a primary and a contingent beneficiary. You can name a third contingent, fourth, fifth, sixth. I mean, I wouldn't go, out to 10 degrees or anything anywhere near that, but you can name contingent beneficiaries. So just some things to think about. Also, as I mentioned, the trust is a great way to avoid probate, but just having a trust is enough. You must fund your trust. I have probated many trusts because the person that created the trust never titled their house in the name of their trust. They never titled their new house in the name of the trust, or they never titled old bank accounts, new bank accounts, brokerage accounts in the name of the trust. They just didn't know that they were supposed to do it. They thought just having a trust was more than enough and they were going to avoid probate. And that was not the case, unfortunately. You should also review your estate plan every few years. It doesn't mean you have to go see an attorney, but look at it, review it. Perhaps you've named a trustee who's passed away, or maybe you had a falling out with them, or maybe they have dementia, or maybe they've moved out of state. They may not be a good option. And let's say you didn't name a contingent trustee, and if they're not able to act or they're unable to act, then you end up having to go to probate court to get a trustee appointed. It doesn't mean the court takes jurisdiction and continues the supervision, but it's just an extra headache, an extra fee, extra time involved in administering the trust. So as your life changes, so does your estate plan. And as it changes, just think about your estate plan and whether it still reflects your current situation, your current values, as well as your current situation. So I think we have come to an end, and I want to thank you all so very much for being here. I know every family situation is different, and because you've joined me tonight, I'd like to offer you a free consultation if you're interested in going forward or learning more about estate planning. So if you would like to contact my office, and the information is here to set up an appointment, just mention the webinar, and as long as you've made the appointment before July 15th, it doesn't mean you have to have the appointment, just make your appointment before then. Your consultation with me will be free, and the consultation is usually about an hour. And we'll talk about what kind of plan will work for you. So let's see, I don't know if anyone has asked any questions. There aren't any. Wow, either I've explained everything so clearly that everybody understood exactly what I was talking about, or you're shy. If you have any questions, let's see here. I don't know if you can still see the screen. You can contact me at Christine@southbayelderlaw.com, and I'll be happy to answer any questions that you have. So thanks again for joining me, and I hope you have a nice evening. Thanks.